I'm going to have Luke go ahead and read through the Zoom portion of the meeting categories.
All right, thanks everybody. I know you've heard it before, but we're going to go ahead and do it again. Good evening and welcome to the June 3rd Board of Zoning Appeals meeting. My name is Luke Mortensen and I'll be facilitating the Zoom video portion of tonight's meeting. With me is Catherine Week, Planner and Staff Liaison to the Board of Zoning Appeals. We will work with the chair, who I believe will be coming a little bit late, but on remote video to facilitate tonight's meeting. Currently, everybody should be muted so we can talk through the general rules. This is being recorded and broadcast live on the city's YouTube channel and public access cable channel 25. During the meeting, please mute yourself by clicking on the microphone icon. When you are muted, a red line will appear over the icon. This will make it easier for everybody to hear the meeting. Of course, unmute yourself if you want to speak. In the menu, you can turn your camera on or off by clicking the video icon. Please keep it on for the portion of this meeting. If you are participating by phone, you can enter *6 to mute and unmute your phone. Somewhere on your Zoom screen, there'll be a choice to toggle between speaker and gallery view. Of course, speaker view shows the active speaker. Gallery view will show all of the meeting's participants. Board of Zoning Appeals does not screen share. A few reminders to ensure the provisions of the Kansas Open Meeting Act. Members must state their name and title each time they speak. City staff will be doing the same. I don't believe we have applicants with us tonight, but they would also do the same. Individuals will provide public comment. I don't believe we will have any of those tonight. If there are any in-person public comment, we'll call on those as well. Again, I don't think we'll have any of those tonight. All motions need to be stated clearly. Staff will call on each commissioner to take their vote. And then staff will announce whether the vote carried and the count of the vote. Finally, once again, everybody please mute yourself when you're not on. Let's see, I don't know if Chair Harrod is with us. Catherine, do you want to go ahead and get going though?
Yeah, so I think, and I'll check with Randy, but I think because the chair and vice chair are both gone, the staff liaison as the secretary for the board can go ahead and run through the agenda for the meeting. Is that correct, Randy?
I think that's fine. Either that or, the members can choose somebody from the board.
Okay.
Either way would be fine.
Okay. Well, if the members don't have an objection, I can go ahead and take roll to call the meeting to order. All right, Clark. Falvey.
Here.
Gardner. Harrod. Rankin.
Here.
Shalinsky.
Here.
Weissner.
Here.
Okay, and we have quorum. So this is Catherine Week, staff liaison. So the first item on our agenda is to acknowledge any communication to come before the board. Were there any communications that any members would like to bring? The staff does not have any communications additional for the board at this time. Item number B, any disclosure of ex parte communications and or abstentions for specific agenda items. Hearing none. C, announce any agenda items that will be deferred. So we do have one public hearing item that was noted on your agenda. That item has been deferred by the applicant. So that item is deferred. So moving on to item D, which is miscellaneous. Tonight we are going to have our Kansas Open Meetings Act training, and Randy Larkin is from our legal office is going to provide that for us this evening. We can go ahead and get started.
Good evening, members of the BZA. I'm Randy Larkin, Deputy City Attorney, and tonight we're going to go over the Kansas Open Meetings Act and the Kansas Conflicts of Interest. Luke is going to run the slideshow presentation for me, or PowerPoint. And while these aren't the most thrilling subjects, they are very important to keep yourselves and the city out of trouble. To keep it, a little bit more interesting, if you have any questions or comments as we go along, to keep this a little more interactive, that would be greatly appreciated. Otherwise, we'll just dive right in. Now, the Kansas Open Meetings Act was enacted by the Kansas legislature in 1972. It came as part of a wave of government reform coming out of the 60s, and it has been described as cornerstone of public access to local and state government. And its fundamental purpose is to require that local government, state government, do their business, especially when it's business of the public, in front of the public's view so that the public can observe it. Kansas public policy underlying KOMA is that a representative government is dependent upon an informed public. So that's the main purpose for it. And so for that reason, it is an express violation of KOMA if we were to try to subvert or move a meeting to avoid conducting the business of the public in the public. The courts construe KOMA broadly and its exceptions narrowly. So basically that means if it's a close call, it's not going to go in the city's favor, it's not going to go in your favor. So we try to be very conservative when we apply KOMA and when we try to comply with it. All right, now there are two criteria that have to be met before KOMA applies, and that's the Open Meetings Act, KOMA. The body, first of all, involved has to be a covered entity, and there has to be a meeting as defined in the act. Now, you can go to the next one, Luke. Bodies that are subject to the act, it applies to all legislative and administrative bodies, state agencies, political and taxing subdivisions. That includes both the city and the county. It also applies when they receive or expend supported public funds, and that would also be the city and the county. And it also applies to all sub-agencies and all departments of those bodies. So it would definitely apply to the BZA. That's not the big issue. The BZA is definitely covered by KOMA. The question is whether or not there's a meeting such that KOMA would be triggered. And this is where all the litigation, this is where all the issues reside. For there to be a meeting, there has to be three things that have to occur. There has to be a gathering or assembly in person or through the use of telephone or other interactive medium by a majority of the membership of the body and for the purposes of discussing the business of the affairs of the body. Let's go over that again. There has to be a gathering or meeting of the members by a majority of the membership for the purpose of discussing the business of the public body. So we'll go through each of those one at a time. An interactive communication is defined as if you meet, like tonight, or if you meet present in public, that's obvious. Telephone calls, conference calls, Zooms, work sessions, staff briefings, anytime where there can be interactive communications where people can exchange ideas or concepts or discuss matters, then there is an interactive communication. Next. A majority of the membership, there are 7 members on the BZA, so a majority of the membership is 4. So before there can be a meeting, there has to be 4. And finally, they have to discuss the business of the body. Its discussion is really what triggers the application. It doesn't have to be a vote. It doesn't have to be binding action. It just has to be a discussion among a majority involving, the matters before the board. Social gatherings are not subject to KOMA. So afterward, if you go out and have a beverage or go walk in the park and don't discuss the business, there's no problem. Commissioners or board members can attend conferences related to it, but as long as they're not discussing the specific business of the body, then that's not a problem. You can go on to the next one. Electronic communications is a big situation today. The mere fact that a communication is electronic does not necessarily raise a KOMA issue. However, it may, especially if you are engaged in interactive communications. A single email to other members would probably not be a violation, but participation in like in an online chat room, instant messaging back and forth may perhaps considered a violation because of the interactive nature of that media. Simultaneous Facebook posts where they exchange ideas could be regarding the concerning of the body, could be meeting under KOMA. In 2020, I believe the Kansas Attorney General, I think this came down from around Pittsburgh, down southeast Kansas. They were discussing a matter that had been before a planning commission, I believe, in that city, and we're on Facebook, and we're exchanging ideas about something that they had just voted on, and we're talking about things back and forth. Someone turned them in, and the Kansas Attorney General found that they had violated KOMA by discussing the business interactively among more than half of the body. So next slide. So that if you use technology or advanced technology, it can directly affect the compliance with these important state laws. So whenever you use Facebook, Twitter, or other social media, make sure and be mindful of those 3 rules regarding whether or not might be a violation of KOMA, and think twice before you post anything. Emails. Avoid initiating online discussions with fellow members through emails. You may obviously receive emails from the city regarding scheduling or subjects that are going to be on the agenda packet itself, some things like that. Those are all fine, but avoid hitting reply all. You hit reply all, and all of a sudden now it becomes perhaps an interactive situation. So always try to avoid or refrain from hitting the reply all function regarding emails on the board. Another thing to be concerned about, another thing to think about is serial meetings. Now, there have been several cases about this in Kansas. A serial meeting basically is a meeting of not a series of interactive communications regarding involving less than 4 members, but that could be spread out among more than 4. For example, what happens is Commissioner or Board Member A communicates with Board Member B, and then Board Member B communicates with Board Member C, et cetera, et cetera. And once you reach the 4th member and you're discussing members of the body, you could very well have a violation of KOMA. And there have been a number of commissions and governmental bodies that have gotten in trouble for conducting serial business or serial meetings. For example, hey, Commissioner A is going to vote this way. What do you think? I think this. And then that person passes on to somebody else. So be aware that you don't have to be all together at one time, but these serial communications among each other can lead to a violation of KOMA. Next. So just to review, the body must be a covered entity. There has to be a meeting, and for there to be a meeting, there has to be interactive communication involving 4 members of the BZA, and you have to be discussing the business of the body. I used to give advice regarding this last one. I didn't bring this up, but you can talk about past things. But in this last case that came out of the Attorney General, they were talking about something they had voted on earlier in the week, and they still were found to be in violation. So be very careful about talking about things that are before you or have been before you when you talk to each other. All right, next. All meetings of a public entity like the Board of Zoning Appeals must be open to the public. Proper notice has to be given. So, it was easy when we held these meetings in City Hall. We had the doors open, anybody can come. We always posted notices on the city website. So now we're on Zoom. So there's certain things that we have to do to make sure that people have proper access to these meetings. They can either come to City Hall and watch it on television. We give them the Zoom passwords. People can call in. So those are things that we have to be done. They have to be accessible to the general public. And the meetings have to be conducted in front of the public so that they can observe and listen to the proceedings. Next. Notice has to give the time and place. There isn't any recommendation regarding when they have to be done. It it has to be given enough time so that people can respond and have a meaningful opportunity to attend and appear and watch. BZA, for example, and then one of the things that needs to be said is that you cannot, like cameras, cannot prohibit them, but we can place reasonable limitations on those. All right, next. KOMA does not require that agendas be created, but if you do create one, which we do, it should include the topics planned for discussion. Agendas can always be amended, but if agendas do exist, copies must be made available to those who request them. We typically make them available to anybody, but under state law, you have to make them available to anyone who requests them. Next. All right, regarding KOMA, that's pretty much the overview of it. Now we get to the nitty and the gritty of it, and it's the penalties version of it. Luke, you can go back. We'll come back to the start of that one later. Anyone who is aggrieved by a potential violation of KOMA has the right to sue KOMA, or the members individually can sue the city. The district attorney or the attorney general are empowered to bring an action to enforce KOMA. Remedies against the board and against yourselves can include injunction, mandamus, civil penalties, payment of costs, or other appropriate penalties that are deemed relevant by the court. If an action is brought in district court to enforce KOMA, just to give you an idea how important the state thinks this is, it will take precedence over other things that the judge may have on their schedule. The judge, he or she may have to move things to hear this within a particular point in time. Another thing of interest is that the burden of proof is switched. It's usually on the person bringing the lawsuit. In these cases, the burden is on the governmental entity to establish that they met the requirements of KOMA. So that's kind of a steep burden. So if there is a lawsuit and there is a violation found, any action that's taken by the BZA could be voidable by the court. They could just erase it. Civil penalty of up to $500 can be assessed to any member of the board for each violation, for each knowing violation. Now, there doesn't have to be a specific intent to violate the law. It just has to be knowing. So you just have to know that you're engaged in the conversation or you are talking to somebody. That is enough to establish guilt, or at least a guilty mind, as they say, mens rea. The court may also issue injunctions against the BZA, could overturn your decisions, and then, of course, the cost of the action can be enforced against you and can be enforced against the city. Now, usually it doesn't get this far. If we find out there's a violation of KOMA, we usually would self-report. And the situation is then you get your name in the newspaper, and you have to go to a lot of classes on Open Meetings Act that are hopefully more impressive and better put on than this one. But that's what's going to happen if there is a violation. So anyway, that's the Kansas Open Meetings Act. And if you're aware of those rules, then hopefully we can all stay out of trouble. So if you have any questions or comments before we jump into the next category, that'd be great. Any questions on KOMA? All right, very good. The next issue is conflict of interest and basically the local codes of ethics and things. Now, basically, the purpose of these laws, and this also came out of the same wave of government reform, is that is to ensure that public office is not used for private or personal gain. So just to let you know, as members of the BZA, you're considered a local government officer for the purposes of the statute. And you can go to the next statement. Basically what it is if you have a substantial interest, you can do a substantial interest in anyone appearing before the board. You can take one of two actions to avoid getting into trouble. If you don't take either action, that's when trouble happens. But anyway, the two things that you can do is you can just simply abstain, which we would have you go blank and you do not participate in the discussion or the vote. or if you have filed with the county board of, or not the Office of Elections, the county election officer, if you file a statement of substantial interest, then whether or not you have an interest in the entity appearing, then you can still participate as long as you've made that transparent and everybody in the public can go look and say, oh yes, this person has an interest in that company or used to be related to this person or whatever it is. So what is a substantial interest? Because that's the most important thing under the state law, is what is a substantial interest, because that triggers whether or not you need to abstain or file the statement. And there are 5 different things that become statements. If you or spouse has owned within 12 months preceding the thing appearing before you, legal or equitable interest exceeding $5,000 or 5% of any business, whichever is less, then you have a substantial interest in that business. So if AT&T comes before us with a big project and you're hearing a BZA thing and you own $5,000 of shares or stock in AT&T, you have a substantial interest under the state statute, and you would need to either report that or abstain. And it could be a local business if you have a share of a local business and it's 5% or more. It could be an LLC, and if you're involved in an LLC, those are the types of things that this section is talking about. All right, Luke, on to the next one. If you or a spouse, collectively or individually, has during the preceding year received compensation or required to include as taxable income up to $2,000 from any business or combination of businesses, then you have a substantial interest. Now, this is obviously aimed at getting at your employer. So obviously, if your employer appears before the BZA, you would have a substantial interest in that situation. Or if it's your spouse's, or if you did some type of other consulting work or other type of work where you received work, payment from them. If you're a contractor and did somebody work on somebody's house and they paid you more than $2,000, then you might very well have a substantial interest in that developer or that builder. So these are all things to be concerned with. That's the purpose of this one. All right, the next one, Luke. If you or your spouse, either individually or collectively, have received within the preceding 12 months $500 or more from a business or combination of businesses, then you have a substantial interest in them. So, for example, you go to Hy-Vee, put your name in a hopper and a raffle, and you win a $500 shopping spree at Hy-Vee, you now have, for the next year, substantial interest in Hy-Vee. Or if someone gives you a gift of $500, say you're going to run for city commissioner or something, and someone makes a campaign donation to you, and it's more than $500, you need to either disclose that or abstain. That's what this one is aimed at. All right, next, Luke.
Randy,
What one is? Yes?
a question. Back to that other one. Let's say I'm on the board of a nonprofit and I go to Hy-Vee and I ask for some donations and they give donations to Ballard. Does that count?
That does not count because that's not for your own personal gain. That's for the gain of the Ballard situation. And there is an exclusion for certain things regarding nonprofits. So you're definitely okay in that regard.
Thank you.
For this one, if you are a director, officer, associate, or partner of any organization other than certain not-for-profit organizations like the Boys and Girls, then you're considered to have interest in that entity. So if there's a not-for-profit organization or something that comes before the BZA and you're on the board of directors or you're an associate or you have some relationship to that in that situation, then you would have a substantial interest in that entity. Now, this again does not apply to 501c3, C4, C6, etc. Those are basically exempt from that requirement. On to the next one, Luke. And finally, if you receive, basically what it is if you receive commissions or fees for anything that you do in excess of $2,000 from anyone, then you have a substantial interest. For example, if you are a real estate broker or agent and you sell a house and you receive more than $2,000 from somebody, now you have a substantial interest in that person. If they appear before the BZA, say they're seeking a variance or they have some other type of issue. So you have to be aware of that type of deal. But this is basically getting at commissions, $2,000 for this, or it could be stock exchange, some other type of deal like that where it's the business is done on a commission. So anyway, that would be a substantial interest where you have to report it. And so if you have a substantial interest, as I says, you can either file a statement of substantial interest with the county election office in Douglas County, which I think is down in the old courthouse. And if you do so, you can, even though you have that interest, participate in anything appearing before the board. You can vote, you can discuss. The other thing that you can do if you haven't done that is you can go to the next one, Luke, is abstain. So those are the two things that you can do. If you've abstained or if you've filed your statement of substantial interest, then you cannot get into trouble with state law. Now, abstaining is easiest, and sometimes, you know, if it's your family member appearing before the board or somewhat an old partner, somebody you have a close personal relationship with, your next door neighbor, sometimes abstention in those situations based on, you know, just the appearance of impropriety is sometimes a good idea just to avoid any situation that looks bad. But under state law, you're not actually required to do that unless you have substantial interest in the entity appearing before the board and you have not filed a statement with the county election officer. All right, next, Luke. Now, penalties, this is a little more serious than KOMA. I mean, KOMA is very serious. But if you violate this statute, it's a Class B misdemeanor. So it's actually a crime. You will have to go, you will be in court, you will be charged with the crime. And the penalties, if you are convicted of violating these statutes, you can get fined up to $1,000. You can spend 6 months in jail or $1,000 and 6 months. So this is a serious crime. I mean, there are more serious crimes, but it's a serious crime. That's how important it is to the state that these be followed, that it's a Class B misdemeanor. Next, Luke. Now, if you have any issues, you can always contact our office. So if you have a question as to whether or not you have a substantial interest, you're always free to contact the city attorney's office, and we will provide you with an opinion. Otherwise, there is a state of Kansas Governmental Ethics Commission. You can contact them, and they will write you an opinion. And if you follow that opinion, even if it's later wrong, you will have been presumed to have acted correctly. So if they say, oh yeah, that's no problem, go ahead and proceed, and then there's later a charge or a complaint raised, you have this letter and can say, look, I have this, and you have immunity from any type of prosecution or anything a problem with that law. And I think my number is on the handout. I think that's my number for the city handout is on that thing. This is the number and address for the Kansas Governmental Ethics Commission. I don't know exactly how long it takes for them to respond or get issues to you, but I think they do it in a couple of days if they can. I guess it probably depends on how much business they have before them. Otherwise, if you feel, you know, if it's okay, you can contact me or our office at any time, and we'll help you the best that we can. So anyway, that's the conflict of interest. There's also a city ethics, basically, policy that went into effect a couple of years ago. And it's in the handout. I'm not going to go over each of those. You can read those. There's 10 little things that, you know, would be a violation of the city ethics. You're required to follow the city ethics policy, and I believe the county has one. And you would also, as a BZA representing both the city and county, are required to follow the county ethics policy. And with that, I really don't have too much more. I will answer anyone's questions if they have it, and otherwise that's Open Meetings Act and substantial interest, conflict of interest.
Catherine Weeks, staff liaison, do we have any questions for Randy? If not, thank you very much, Randy, for the training.
All right, thank you. And everybody, we appreciate your service to the city. It is greatly, city and county, it's greatly appreciated. You provide an invaluable service to all of us. So thank you on behalf of the city.
Thank you.
Everybody have a good night.
Okay, Catherine Week, Staff Liaison. With that, we have a couple more miscellaneous items.
So July is our upcoming meeting. It's July 1st, and typically July is a heavy vacation month. So we're just kind of taking a general poll to see if there are any board members that are going to be out for July 1st. We're trying to determine early whether or not we will have quorum for next month. So if I can go down the list, and if you can just say yes or no, that you would be able to attend the meeting July 1st, that would be appreciated. Falvey,
Yes.
Gardner,
I think so.
okay. Rankin,
Yes, I'll be able to.
okay. Shalinski,
I may be traveling, but if we're still on Zoom, I will make it.
okay. And Weisner,
I'm a no.
no, okay. Okay, and then one more item of miscellaneous. So we've had a couple questions about whether or not we're going to continue our Zoom meetings. And just to let you know that when there is a change in protocol, or if we're going back to in-person meetings, you all as board members will be receiving an email directly from fourth floor, from the city manager's office with those protocols or directions or how that is. So at this time, staff does not have any information that we're changing what we're doing. We're still doing Zoom as far as we know for now. But if there is a change, you all will probably hear about it just as quick or before staff hears about it. So you will be in the know. You'll get an email directly from the city manager's office with that change. And so that's all the updates that I have. We do have a couple items coming up for July. I actually will not be physically present for that meeting, but I will be Zooming in. So Luke is going to run that meeting in July. So that's all I had as staff. Unless there's any discussion from the members, I would be happy to hear a motion to adjourn.
Hey, Catherine, this is Eric. I
Yeah.
have a question.
Yeah.
Have we changed the policy on sending out the agenda and the request for participation via email?
We haven't changed the policy, but we have lost a previous staff member, so the procedure may not have run exactly the same. I do believe there were some extraordinary processes that happened in the past. So we can, if you all would like direct emails, we can do that. We did have someone else who was sending out agenda information this time, so we can get that ironed out if that wasn't smooth enough.
Well, I don't really care. I mean, it's up to you guys on the participation side, but it would be nice to be informed of the agenda a few days in advance, because I didn't get anything. I had to reach out to you, obviously, you know that, but.
Okay, so just that the agenda has posted, that notice that it's up and that you can go and view that when you're ready, is that what you're referring to?
Well, yeah, but I mean, even then, it still says the agenda tonight said it was the meeting was being held at City Hall. Usually we get something that's saying that's like there's a Zoom meeting, please register for it.
Oh, I see. So you didn't get, okay, so you didn't get the email with, yeah. So there is on the agenda at the top, the registration is there. So I guess we've dropped the ball in sending out an additional email with that link, and we can certainly keep doing that if that's needed or if that's helpful for a reminder. Yes, we can do that.
Or in the
Yeah, I
notice, remind us where the link is.
Okay,
Yeah.
we can certainly do that.
Sorry, I didn't know if I was the only one that didn't get it or what, but it was totally different this month. So.
Yeah, no, I had a couple inquiries from several board members about agendas and process in the meeting and what, was happening tonight. So that's duly noted that we need to just make sure we've got that cleaned up in the transition, so.
Okay, thanks. I appreciate that.
Yep, no problem.
So does that mean, Board Member Garner, does that mean Caitlin's gone?
Yeah, Caitlin is in Georgia, so yes, Caitlin is not here.
Okay.
All right, well, if there are no other questions or items for miscellaneous, I would entertain a motion to adjourn.
Board Member Gardner, motion to adjourn.
Member Falvey, I second that.
So staff liaison Catherine Week, Falvey,
Aye.
Gardner,
Aye.
Rankin,
Aye.
Shalinski,
Aye.
and Weisner.
Aye.
Thank you all for attending. Have a good evening.